Action Visa Assistance is not a law firm. We do not provide legal advice. This information is for educational purposes only based on past experience with H2 programs, is not to be considered as engaging in rendering legal, immigration, and/or other professional advice. Should you feel you need legal advice, please contact a board-certified attorney or a tax professional.
Hi, my name is Douglas, and on behalf of our staff at Action Visa, I'd like to welcome you to our webinar on compliance for H2B employers. This segment addresses domestic recruitment, which is a crucial part of the H2B process, and it is imperative that the recruitment and the documentation be accomplished properly. The basis for the H2B petition is that there are not enough local workers who are willing and available to meet your temporary or your seasonal need. With the Buy American, High American Executive Order and the Memorandum of Understanding signed by the Department of Labor, Department of Justice, USIS, and Department of Homeland Security, who are all working together to identify employers who hire foreign workers, it is now more important than ever to make sure that you are following the rules and that you're documenting your recruiting efforts. It must be clear to the government that you want to hire U.S. workers first and that you will only hire foreign workers as a last resort. When the U.S. Department of Labor, the Office of Foreign Labor Certification, accepts the petition, they will issue a Notice of Acceptance, or what we refer to as an NOA. The certifying officer from the Office of Foreign Labor Certification will specify the recruitment steps the employer must take. Employers are required to conduct active recruitment of U.S. workers to ensure that there are not qualified U.S. workers available for the positions listed in the application for temporary employment. U.S. applicants can only be rejected for lawful job-related reasons. For active recruitment, the regulations require employers to contact, either by mail or any other effective means, any and all former employees whom you employed in the occupation at the place of employment during the previous year and inform them of the terms of the job order and solicit their return to the job. Employers are not required, however, to contact former employees who were either dismissed for cause or who abandoned the job. Unless otherwise instructed by the certifying officer at the Office of Foreign Labor Certification, the employer must conduct the recruitment described in the regulations within 14 calendar days from the date the Notice of Acceptance is issued. All employer-conducted recruitment must be completed before the employer submits the recruitment report as required in the regulations. It's important for employers to remember that you must continue to accept referrals and the applications of all U.S. applicants interested in the position until 21 days before the scheduled date of need start on the job order. Employers that wish to require interviews must conduct those interviews either by phone or provide a procedure for the interviews to be conducted in the location where the worker is being recruited so that the worker incurs little or no cost. Employers cannot provide potential H-2B workers with more favorable treatment with respect to the requirement for and the conduct of interviews. The employer must consider all U.S. applicants for the job opportunity and must accept and offer employment to any U.S. applicants who are qualified and who will be available during the period of time of the contract. A recruitment report has to be submitted, and the recruitment must comply with the job order assurances required by the regulations. When we receive the Notice of Acceptance from the Department of Labor, we will send you 2 emails. One is to the newspaper, and we copy the employer. This contains the approved job order and job posting, which cannot be altered in any way. The newspaper will quote the cost to the employer who has to pay for the ad. Both we and the employer need to have the tear sheets for each ad that runs. The second email has recruitment instructions that are seriously important for you to follow. It will include your account ID and your password for the state workforce agency account where your job ad has just been posted. You must monitor this account for any referrals of U.S. workers, and you must keep records of all inquiries and your correspondence with the potential worker until 21 days before your scheduled date of need start. The second email will also include instructions for you to print and post the recruitment posters that must be conspicuously displayed in your workplace. It will also give you a deadline for you to have scheduled your interviews. We must submit the results of your recruitment to the Department of Labor by a specific date. After the initial recruitment report is prepared and submitted, employers will still have to continue to monitor and track any applicants for your final recruitment report. This must be maintained in your records to show U.S. Department of Labor if you are ever audited and are asked for your final recruitment report. Employers are strongly advised that all interviews should be scheduled and conducted during normally acceptable business hours, 8 or 9 a.m. to 5 or 6 p.m. All applicants must have been offered an interview with enough advance notice to be able to attend. If an applicant is referred to you by the state workforce agency, you must send an interview notice to the applicant through the state workforce agency website. You need to include the interview address, date, and time, and include the statement, "If this time is not convenient, please call me at XYZ to reschedule." Department of Labor recommends a cell phone number that is monitored closely, as they can call to make sure that you're available. If you were contacted by means other than the state workforce agency, ask for their full name, their address, phone number, and email address if they have one. Send them a notice of interview via email and print the email as evidence of notice. You can also use the delivery confirmation and the read receipt tools in your outbound email. If an applicant has no email address, make sure that you record the date and time and any notes for any phone calls that you make, and send any correspondence via certified mail so that you have a record of your correspondence. And finally, we recommend that a single person be designated as the point of contact for all hiring or job inquiries. All other employees of the company should only say, "You need to talk with so-and-so," and make absolutely no comments about whether or not the company is hiring. It is important to remember that any person contacting you about your job posting could either be a U.S. Department of Labor agent or could be a person who will be contacted by a U.S. Department of Labor agent asking about their application and their correspondence with you. That concludes our webinar for employers on domestic recruitment. Thank you for attending and for your time and patience.